For the court this morning is the case entitled Roy v. Roy, case number 24 AP 051. Representing the appellant, Andrew Roy, is Nikki South. Representing the appellee, Crystal Roy, is Jacob Oblock.
Thanks very much, and good morning again, everybody. We'll hear from counsel for the appellant. First, of course, please, counsel, introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. My name is Attorney Nikki South, and I represent the appellant, Andrew Roy.
Thank you.
At this time, we're requesting that the court reverse and remand this matter for additional consideration due to an abuse of discretion. While we do appreciate that the standard is quite high to determine an abuse of discretion, we do believe it's warranted in this matter. The findings in this case by Judge Bent do not support the order that the court issued. In fact, the court weighed only one of the best interest of the child factors in favor of mother and otherwise deemed them to be predominantly neutral. While generally that would be sufficient, in this case in particular, the findings are not warranted given the evidence that's in the record. Specifically, the findings are conclusory based on the evidence that was presented. Specifically, they're speculative as to how father's quote unquote controlling nature would impact his ability to meet the child's developmental needs moving forward. We think this is particularly problematic as, of course, there's no way for the underlying trial court to understand how that child will age or individuate moving forward and how her relationship with her mother will blossom over time. Moreover, in awarding sole legal and physical parental rights and responsibilities to mother, the court made a decision to essentially remove the child from her home state of Vermont, the only home that she has ever known and where all of her connections are. Certainly, mother and any divorcing parent has the right to move to whatever state they choose when granted custody of their child. But in this case, mother had specifically made the argument that should father be awarded parental rights and responsibilities, she would remain in the state of Vermont. Which brings us to the second reason why we believe that this order should be reversed and remanded for reconsideration. And that is the parent-child contact order that was issued feels punitive in nature. In this case, the appellee notes the Bancroft decision stating that an order of 25% did not offend public policy in the state of Vermont. That certainly is true, but in this matter, we have a parent who was determined to be at least as much of a primary care provider as the mother in the only state that the child has ever lived in. And father's time was reduced to less than 15% during the school year, with significant restrictions allotted for his travel during that period. Father is not permitted during the school year to have any contact with his child in his actual home. There is limited holiday contact that is permitted under the order, and the findings do not elucidate why the court made that decision. In the summertime for parent-child contact for mother is awarded 3 weekend visits, taking up 12 of the summer days that father was awarded, and she may travel wherever she wishes or return home with the child. That is not the case for father's parent-child contact time during the school year, where he is required to be in the state of New Jersey. All of the burden for travel, as well as all of the burden financially for accommodations during that period, is also placed on father, with no explanation as to why those should not be shared given the court's restrictions. So under these circumstances, we do believe that it is not supported by Vermont public policy, and we also do not believe that the evidence provided in the record supports the findings and analysis the court made issuing the. And I'll reserve the rest of my time if the court has no questions.
Okay, thank you very much. We'll hear from counsel for the appellee now. Please identify your client, introduce yourself, and then proceed.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. My name is Jacob Oblock, and I represent the appellee, Crystal Roy, in this matter. Some appeals reach this court to decide, some family court appeals reach this court to decide whether a trial court did enough analysis under the best interest factors. This is not that case. This case is actually the opposite. don't get the sense from appellant's brief that appellant is arguing there wasn't enough analysis. Instead, it appears to us that appellant's primary argument is that there was too much analysis. And the trial court did go through all of the best interest, almost all of the best interest factors, item by item, line by line, and provided analysis for almost all of them. I mean, appellant recognizes in their brief that the trial court didn't even have to go that far, but it did. And it appears that the appellant, however, is arguing that the trial court went beyond that. It did more than that, more analysis, and provided analysis on father's controlling behavior, as it had been applicable to child making decisions. I would point the court to PC4. It did affect the child. I know that appellant's argument was to the contrary, that it didn't. It had. And in this case, the trial judge was looking at all of the factors as a cohesive whole, but also considering all of the relevant facts and other factors that this trial judge considered relevant in this case to this child. And that is specifically allowed under the plain language of 665B itself. That statute specifically says, in making an order under this section, the court shall be guided by the best interests of the child and shall consider at least the following factors, of which there are 9. I think that the words "at least" plainly support this court's line of cases, as cited in our brief, that do support that the trial courts can expand that analysis as needed on a case-by-case basis when fashioning an equitable order or when looking at the best interests of a child. We don't believe that there was speculation in this case. Father's penchant for control, according to the trial court, did and would affect the child, given that father had already exhibited those behaviors on issues specifically related to child rearing. And again, that's PC4. Those were unilateral decisions made that the court was finding related to the child. I think it's a relevant factor for the courts to consider, even where the court is not awarding a shared legal and physical arrangement by agreement, but where the court is having to award one parent legal and physical rights and responsibilities. The court is free to look at how well those two parents are able to involve the other parent in making decisions, even if they have the final say. And we think that the trial court did that here. And we think that that's actually a good thing for trial courts to be thinking about, because when one parent has that right to make a decision in a child's life, a big decision affecting the child, it most often would be best for that parent to take into consideration what the other parent has to say and the reasons for the other parent's opinion on the matter, even if, again, parent A still is the one that is awarded legal rights responsibilities. So we believe that does affect multiple factors, like the trial court found that it did. And we actually would respectfully disagree with the appellant's characterization that only one factor favored the appellee. We think that the court could look at the trial court's decision and look at factors 2, 3, 5, and 6. And we believe that, however slightly, the trial court was finding that those factors favored the appellee, other in this case. For all of those reasons, we believe that the trial court was well within its considerable discretion in fashioning its order. We believe it appropriately considered the factors and every fact that was relevant in this case. As argued in our brief, we believe that the facts the trial court found were supported by the evidence, that the conclusions the trial court made were supported by its factual findings, and that its order was supported by all of that.
You have 1 minute, counsel.
Thank you, Judge. And for those reasons, we believe this court should affirm the order as appropriately rendered. We thank you for your time.
Okay, thank you. How much time does the appellant have, please?
Appellant has 1 minute and 4 seconds remaining.
Counsel?
Your Honor. So appellee claims that we are suggesting that the trial court did too much analysis. We are not. We are grateful for the analysis that was rendered. However, we believe that it does demonstrate an abuse of discretion because it is not logically connected to the findings. In this case, the factors that appellee claims weighed in mother's favor in this case demonstrate that father was a parent who took a strong interest in the upbringing and of his child, and that mother in this case was in a situation where, because of her deferential nature, she chose not to argue. Somehow the trial court looked at that and weighed that in favor of mother and accused father of being controlling in nature. Because this is not a shared custody situation, An order can require one parent to seek the input of another. Whether or not mother has an inherently deferential nature is not something for the court to bear in mind. It is the best interests of the child. And in this case, father was the one who was being proactive. Mother was unable.
Ms. South,
Yes.
let me just
Thank
ask you a question. I'm sorry for interrupting. Isn't the characterization by the court in its order that it wasn't so much dad had more of an interest in the upbringing of the child, but rather he did not foster a positive relationship between mother and child, which is one of the factors that the court considers in terms of best interests, the parent foster a positive relationship. So can you address that for me, please, with your argument?
In the court's findings specifically, the fifth factor analysis says that this was not an acute concern. The court suggested that the plaintiff's controlling nature may negatively impact his ability to maintain that relationship, but also claimed that neither parent appears to have tried to keep the child from contact with the other parent. That continued to be the case. They had shared custody in 50-50 time during the duration of the temporary order, and there simply isn't evidence that father wasn't willing to engage in that positive relationship development between mother and child.
Okay, your time has expired, counsel.